Yeah, so the first thing that we should think about is sort of recall what the International Court of Justice did and pronounced just last July. It pronounced that Israel's very presence in the occupied Palestinian territory is an internationally wrongful act, by which it means it is an aggression. They're not entitled, as a result, the Israelis, to physically remain in the occupied Palestinian territory at all. So that's the first thing. But the court also reminded us last summer that to the extent the Israelis do remain in the occupied Palestinian territory, they remain an occupying power, albeit an illegal one, and bound, therefore, by certain obligations under international humanitarian law, the laws of war, and human rights law, which in effect can be sort of summed up in the following: that the occupying power has the obligation to maintain its governance over the occupied territory in the best interests of the occupied Palestinian population. Your listeners and your watchers will know that that isn't in fact what's happening. It's quite the opposite. And that is precisely why this question was put to the court by the General Assembly last December. All of this is in response, in effect, to what the Israelis have been doing since 7 October 2023. But it also touches on things that go well prior to that. The situation in occupied Palestine is particularly bad. Forcible transfer, starvation as a tool of war, indiscriminate bombardment. The Nakba continues, and in ways and means that are really unprecedented in the history of the Palestinian people. And so the submissions that were made before the court today focused on the IHL obligations. For instance, the occupying power has an obligation to facilitate what we call relief schemes for the benefit of the protected population. Now, you know, the occupying power has banned UNRWA from operating in the occupied Palestinian territory, and UNRWA, of course, is the means through which these relief schemes had for decades been dispensed to the needy population of not only the Gaza Strip, but elsewhere in the occupied Palestinian territory. So the Israelis have doubled down on their desire to remove the United Nations presence, but primarily UNRWA's presence, from the Gaza Strip. And we fear, and the court heard from us, that this is an attempt by Israel, quite open, to hasten what they're doing to the Palestinian people on the ground. If the Palestinian people in Gaza in particular do not have the means of subsistence, do not have the means of survival, which Israel is required to provide them, then that will hasten what Israel is in fact doing, trying to ethnically cleanse the territory as part of its genocidal campaign against the Palestinians.
Mr. Msesi, you yourself were referring to the previous ICJ ruling, which has been pretty much dismissed, right, by Israel. So once these proceedings are over, correct me if I'm wrong here, what we'll be left with is a non-binding advisory opinion. Could this, however, be anything more than symbolic?
No, it's far more than symbolic. While it is true that the advisory jurisdiction that the ICJ exercises is formally not binding, what it also is an authoritative determination by the principal judicial organ of the United Nations, which is the highest body in public international law on earth, of what international law requires of all states and all international organizations, and in this case, including Israel. And so, in effect, even though it's not formally binding, the law on which the court makes its pronouncements, and the pronouncements themselves, are in fact binding as a matter of general public international law. But it's not so much the law as well that we need to focus on. Whenever the court makes a determination that is authoritative, that determination in law helps shape what is regarded as legitimate politically, from a humanitarian side, even morally. And so third states are obligated, and you will hear the court pronounce, I do hope, on what third state obligations are in respect of Israel's actions in the territory, to follow what the court says. So too is Israel. Now, you mentioned Israel sort of poo-pooing the opinion from the summer and not caring much about it. And I don't think anyone would expect any different. Look what they're doing and have been doing for decades against the Palestinian people in the occupied Palestinian territory. But that, if that is your focus, you'd be missing it. That isn't the focus. The focus is for the General Assembly to receive an opinion from the court determining what Israel's obligations are. And once it does that, for the General Assembly to act in accordance with that finding or with that opinion. And so this is part of a longer process of holding, in this case, an illegal occupying power, an aggressive power, to account.
Okay, we'll leave it there. Ardim Seis, legal representative of the State of Palestine at the International Court of Justice. We thank you for your time from The Hague.